Hi, this is Suman Dash Bhattamishra, Assistant Professor of Law at National Law University, Odisha, Cuttack, and today I am here to discuss a module on the law of domestic violence in India as part of your course in substantive criminal law. Before we get into the objectives and the content of the module, let me first introduce you to the topic. The problem of domestic violence, like many other problems in Indian society, has perplexed and in fact shaken the entire country. The problem of domestic violence has been phenomenal, particularly because of associated social ills like dowry, matrimonial cruelty, etc. So, under this chapter and in this module, I will be teaching you how exactly the law pertaining to domestic violence proceeds in India. So, the objectives of this module are threefold. Firstly, to sensitize students to the problem of domestic violence and the law relating to the issue, to discuss important provisions of the Protection of Women and from Domestic Violence Act 2005 as well as Section 498A of the Indian Penal Code, to discuss significant judgments in the area of domestic violence and matrimonial cruelty. So, before we actually get into the legislation and the content of the legislation, which is the Protection of Women from Domestic Violence Act of 2005, let me introduce you to the prelude which was to the PWDVA, that is Section 498A of the IPC. This section was introduced in the Indian Penal Code in the year 1983 by an amendment and was specially crafted for meeting the requirements of married women in their matrimonial homes. It was the very first manifestation of a law on domestic violence, although it had a very limited scope. The section does not really define cruelty, however, it has an explanation which states that matrimonial cruelty can be of two types, either physical or mental. The problem associated with Section 498A is that it provides only for penal remedies. It does not address all problems and all forms of domestic violence and is applied only to married women, which means complicated relationships like relationships in the nature of a live-in relationship, etc., cannot be taken into consideration under Section 498A. Now, when we talk of 498A, it is only pertinent on our part to look at the provisions under this section. So, Section 498A under the Indian Penal Code talks about punitive provisions for the husband or the relatives of the husband who indulge in any form of cruelty that can endanger the life or the limb of the woman or can have an impact on her in the form of an emotional harassment by causing mental cruelty. So, this section obviously has its target as the husband or the relatives of the husband. The term relatives of the husband obviously connotes that the relatives would be persons who are connected either by consanguinity or by blood relationship. So, parents of the husband, sister or brother of the husband and other relatives of the husband come into the picture. But as per the Supreme Court pronouncement, friends of the husband are not really covered within the term relatives of the husband under Section 498A. Section 498A of the Indian Penal Code also has a protective shield for women who have been victims of matrimonial cruelty. So, which means that a woman who has been subjected to matrimonial cruelty in her matrimonial home can approach the court to seek a remedy which is obviously penal in nature, because the section, as I said, one of the most important limitations of Section 498A is that it does not provide for any penal remedies. It does not provide for any form of compensation, does not provide for any form of other civil remedy which a woman could have taken into cognizance. So, the only form of punishment which is provided is in the form of an imprisonment which can extend up to a period of 3 years. Now, this is a major problem because in civil law, having cases of 498A filed against a husband or the family of the husband is also a ground for divorce. So, for instance, while seeking a divorce under the Hindu Marriage Act and under section 13 of the Act, when we try to establish matrimonial cruelty, cases of 498A which have been frivolous, or in other words which haven't reached a conclusion wherein the husband has been convicted or the relatives of the husband have been convicted for the offence of matrimonial cruelty, is a sure shot ground for divorce which can follow. Now, the requirement of marriage, and marriage being the institution that it is, also needs to have some sort of civil arrangement which doesn't really take the husband or the relatives of the husband behind bars, but at the same time provides for some kind of remedy which is in between, or which can actually be used as a method of mediation or negotiation, and doesn't really have an impact on the breakdown of marriage. So, this is a very significant limitation of 498A, where we take issues in the matrimonial home to the bars of the prison. And another important limitation, as I already pointed out, is that all forms of domestic violence have not been addressed under section 498A. So, when we say all forms of domestic violence, I would mean that the term cruelty, which has been explained in section 498A, covers cruelty which is either physical or mental in nature, but doesn't look into those forms of cruelty which can be part of a day-to-day matrimonial life or a day-to-day married life, and which may be verbal, which may be emotional, which may be economic in nature. And of course, the other most important drawback of section 498A is that it has its application only to married women, which means some sort of marriage between the parties has to exist for the law to come into operation, and complicated relationships in the Indian scenario are not taken into consideration for addressing the problem of matrimonial cruelty. So, it presumes that cruelty between partners or intimate partner violence as a concept in itself will have its relevance only when marriage is in the picture. An exception to section 498A, however, has been the case of Reema Agarwal versus Anupam, which has a factual matrix which is very complicated in nature, and at the same time no one expected the court to deliver a judgment which would be in consonance with section 498A. So, Reema Agarwal was a victim of matrimonial cruelty. However, her situation was very special because she was the one who had married Anupam, having knowledge of the fact that he had already been married and had an existing spouse. The marriage between Anupam and his first wife had not been terminated. They were not staying in a judicially separated manner. However, Reema, who was completely in the loop of facts, decided to get married to Anupam. As fate would have it, Reema faced the problem of dowry harassment and matrimonial cruelty at her in-laws' place, where she accused Anupam as well as his relatives of having harassed her for dowry, and because she could not meet the demands of dowry made by their in-laws, Anupam used to physically harass her, and sometimes the abuse was also emotional in nature. So, one fine day when she was admitted in the hospital, she decided to take this case up under section 498A of the IPC. Now, as we know, section 498A presumes marriage as the fulcrum of application of this section. However, in this case, the court had taken a different opinion. Reema gathered the courage to approach the court despite the fact that she had a marriage which was not recognized in law as valid. Under the Hindu Marriage Act, a marriage with a person who has an existing spouse is considered to be a void marriage. So, the marriage being invalid, the marriage being void, the biggest question which came into the picture was, can we then hold the accused liable for the offence of matrimonial cruelty under section 498A of the IPC. The court made a very logical argument, and the major premise of this argument was that although matrimonial cruelty is based on the existence of marriage, it is not necessary for the marriage to be valid. What is necessary is that the marriage must be existing between parties. What form the marriage takes is not a question for us to decide upon. So, if the parties had been living together as husband and wife, and they shared or had decided to share responsibilities of marriage between each other, they decided to have rights and obligations towards each other because of the marriage, then it would be considered as a form of marriage. And yes, this is exactly where we have decided that matrimonial cruelty could have happened in this case, and legitimacy of the marriage or invalidity of the marriage cannot defeat the very purpose of section 498A. The court went further to state that the section 498A of the Indian Penal Code has the purpose of punishing those men who influence their women by or have an impact on their women by going for domestic violence or matrimonial cruelty. And the purpose of this section is greater than the relevance of the marriage which is in the picture. A man cannot use an invalid marriage to circumvent the provisions of section 498A. So, here we have the case of Reema Agarwal versus Anupam as a case which is very exceptional in nature, and as a case which has been a very progressive one, considering the fact that matrimony has always been the fulcrum of section 498A of the Indian Penal Code.